there, and thank you for joining us here on the Evening Review. My name is Okito Greg, and in studio with me this evening, Mr. Samuel Shinedima. He is a legal practitioner of the High Court of Namibia with a special interest in labor matters. How are you, sir?
Good afternoon. Is it afternoon, morning, or whichever? Well, they say joy comes in the morning. So
yes.
Let's say good morning because I'm so happy to be here.
It's evening actually, but that's fine. You have a special interest in labor matters, and specifically as it is impacting the security interest, it's a security industry in Namibia at the moment.
Right.
This is in the context of recently implemented new minimal wage laws across the industry and across the whole of Namibia.
That's right.
Can you tell us a little bit about your experiences in terms of the cases that you are dealing with?
Ogata, thank you so much. Look, we're actually been more impressed with a lot of labor matters, especially with service providers being taken on to the labor commissioner by their employees.
Yes.
In respect of non-compliance with labor law statutory entitlements.
Yes.
Well, some of them it could either be the normal wage, basic wage, but the majority are more, fights of, my annual leave payouts, Sundays and public holidays and all of those things.
Yes.
Now, what I have now actually realized, and according to my research, because I was trying to understand what is really the issue in here. Is it the guys, maybe the service providers are not willing to compensate the employees just?
Yes.
Or what is really the issue? And of course, the issue has been a bit more calm prior to the, enactment of the new wage order, which
yes.
actually, it gave rise to the 2025 wage hourly rates, 2026 and 2027,
yes.
respectively. Now, what I've now realized is this: there's actually a gap between the procurement model being used and the application of the Labor Act.
Okay.
Now, Ogero, you'll have to understand that these two, the procurement model and the procurement,
the Labor Act.
and the labor provisions, are actually supposed to operate in harmony.
Yes.
When one pulls on the other hand and one pulls on the other side, there has to be a conflict.
Yeah.
And that issue will then affect those that are actually implementing the law, and those are the employees and the service provider. So that's why you find now we have the employees fighting their service provider, but actually all of them are fighting each other, but none of them actually can come up with a solution.
Yes.
Because the solution is actually found in the legislations.
Okay.
All right. Now, why do I say so? Okay, you will have to actually, I will have to take you back a little bit to where it all started. Before 2025, before the new wage order actually, which came into effect in January 1st, 2025,
yes.
the hourly rate for security was $8.75.
Yes.
Okay? Now, a lot of contracts that are currently in force were awarded or were either, bid before the enactment of the new law.
Yes.
Now, you have to understand that, of course, the law does not operate retrospectively. So those that were now bid prior will have to be readjusted in order to comply with the new order.
Okay.
Now, for example, in 2024, the wage order was, of course, $8.75. And the guys would then bid according to that.
Yeah.
They would bid, with inclusion of the hourly rates. And then, of course, they will include their company margin, which includes now profit and other cost.
Yeah.
Now, here is the gap that is now exposed, even though it's been there, but of course it wasn't exposed because, things were, I think the service providers were able to curtail or to take care of these within their bidding process. They had a technique or actually, a really good way of making sure that most of them are able to comply, except those that are taking advantage that don't really just want to pay the employees.
Yeah.
Now, the procurement model or the procurement agencies, when they are actually procuring their service providers, if Rogetto, you have a house and then you tell the service provider that you have two sites.
Yeah.
You will then say in the bidding document that you only want 4 employees for these 2 sites.
Okay.
2 daytime and 2 nighttime.
Yes.
Okay? And then the procurement model would then says they want these people to work, 12 hours a shift.
12 hours a shift, yes.
From 6 to 6, that's the person who is on day shift.
Yeah.
And then from 6 to 6 in the morning for the person who's on night shift.
Yes.
So there's no gap.
Yeah.
There's no interval. So they have to actually take it out, each other out.
Yeah.
Now that means you have these people working 24 hours a day, collectively all of them,
Yeah.
7 days a week, 31 days a month, and 365 days a year.
Yes.
Without taking a break.
Yeah. Yeah.
Simply because now it is as if the procurement model recognizes people as object.
Uh-huh.
They are like logs.
Yeah.
Like we put the log here. It means I logged. This log must be here for this 12 hours.
Yes.
And then I'll come and remove it and put another one again at night.
Yeah.
And this log must be there for the next 12 hours.
Yes.
But now here's the trick. While the procurement agencies or model actually fail to recognize these people as human beings with dignity and rights,
Yeah.
the labor law, on the other hand, recognizes these people as dignified humans
Yes.
who have the rights to interval breaks,
Yeah.
who have the rights to annual leave, who have the rights to sick leave,
Yeah.
who have the rights to other entitlements as per Section 19 of the Labor Act, Section 21 and Section 23 and 17 respectively.
Yes.
Now, so it then means now when most of the service providers back then, when they were bidding, for example, if in 2024, the hourly rate was $8.75,
Yeah.
it then means that the service provider will then quote, for example, maybe their entire financial submission per hour for the entire bid
Yeah.
would probably be $15 or $16 per hour.
Okay.
Now that include everything. They will then subtract the $8.75 for the guard that is quoted for and that is actually requested for in the bidding document.
Yeah.
And the difference, the balance thereafter, goes to what then is called the compliance fund, the operational fund. And that includes anything that is not provided for in the bidding document.
Okay.
Remember the bidding document, for example, only demanded for 4 guards.
Yeah.
But the reality of the operation requires these guys to be supervised.
Yes.
So there must be a supervisor
Yeah.
who is not actually requested for in the bidding document. It's not in there. These guys, their salaries must be paid.
Yeah.
So it means there must be an admin office
Yeah.
that actually has an employee who is authorizing their leave, paying, and this guy must also get paid.
Yeah.
There must be an operational vehicle or patrol vehicle. In order for, without this vehicle, this contract service will not be rendered successfully.
Yes.
These guys must be fully equipped with guns and all the necessary security tools. Now, all of this could not be provided for without this actually be catered for in the bidding document. But since now the bidding document actually omitted this,
Yeah.
so the bidders now include these, okay? And then they say, fine, we are now giving you $16.50, for example. That is our financial submission.
Yeah.
The $8.25 goes directly to the wage, basic wage. And the remaining, this is now where we survive with all the statutory entitlement and the company profit, as well as the compliance fund.
Yeah.
That wasn't an issue. The guys were able to maneuver. Maybe the company gets $1, and then the $2 goes to annual leave payout, public holidays and Sundays, and all of those things.
Yeah.
Now, when the new wage order came in force in 2025 in January,
Yeah.
that's where chaos actually ensued.
Okay.
It actually came to light in the fact that when the implementation of the new hourly rates,
Yeah.
that it must now move from $13.50 to $8.75. I mean, it moved from $8.75 to $13.50.
Yeah.
Okay? So now what the procurement agencies do, or rather the clients or the public entities, whoever is contracting these guys,
Yeah.
they then calculate the amount. They calculate $13.50 minus $8.75. And when they get that difference, that's what they will add. And they would say we have complied with the wage order. But now, there is a whole lot of labor law entitlements that are not provided for in the bidding document, that the bidders were actually made a provision for in the compliance fund. And now, in these now circumstances, what these guys are doing now, they are only adjusting the hourly rates. And this remains not adjusted. So we have two wings. We have the hourly rates, which is only the basic wage, and we have the compliance fund. So the compliance fund carries more weight that actually supports the whole operation. This one only is only for the employee. And even as much as it's only for the employee, it is only in order for these guys to be in compliance with their compensation in respect of the entirety of the Labor Act. Some of them must come from here. And these are not adjusted. So now we have an issue of, fine, the service providers will say, no, can you also adjust this, the compliance fund? Because when you adjust this must grow. Because this actually determines this. Why? Because if you are paying people now $13.50 as opposed to $8.75, it means now that their hourly rates has increased. Their leave payout will also increase. Because their leave payout is determined, or it is dependent on the hourly rates. So that's actually the issue that is there. And it's a gap that now has to be addressed by the policymakers. We must go back to the drawing board. The procurement model must address this in their bidding document. The procurement method, when it only demands 4 people, it means the service provider cannot only employ 2 people.
Thank you very much. I appreciate that explanation for us, and we'll be right back after this commercial break to continue with this important conversation. So please stay with us on the Evening Review. Welcome back to the Evening Review. My name is Okito Greg, and in studio with me, legal practitioner Samuel Shinedima. We are talking about labor issues, and in particular as it regards security guards and the difference, the gap between procurement agencies, their practices, and what the labor law requires, especially in terms of the application of the wage orders. Samuel, you were explaining to us that there's this gap, but I want us to agree on a few things. Firstly, the requirements of the labor law, the rights that they provide to employees, those are necessary. I mean, it's people that we are talking about.
Indeed,
a person cannot work continuously.
Indeed so.
Forever.
Indeed
otherwise
so.
they're gonna get sick and they're not gonna be able to perform.
Indeed so.
So those are necessary.
Yes.
And then at the same time, procurement practices are also necessary in order to maintain and curb costs. So where do you see that the changes or the give has to happen?
Agato, thank you so much. You see, remember what I was explaining earlier was this. Let me give you another example before I illustrate.
Yeah.
So like, for example, the procurement agency will say they want 4 people, 2 nighttime and 2 daytime.
Yeah.
And these people must work because security personnel is like a door.
Yeah.
If you replace that door, if it's broken, you must replace it before nighttime because otherwise vandalism will happen.
Yes, or theft.
Or theft.
Yeah.
Now, when the service provider is now coming on board, if you ask him 4 people, he will have to bring you 6. Why? Because he's considering when this one goes on leave, there is somebody to work on their behalf.
Yes.
And when he's on leave, either sick leave or annual leave, that person who's on leave is getting paid.
Yeah.
And that is the one now the service provider is actually paying for.
Yes.
But the one who is working on his behalf, where that one is on leave, is getting paid by the company, by the service provider. But that money is coming out from the compliance fund.
Yes.
This person is not provided for in the bidding document.
Yeah.
But the procurement contract cannot be fulfilled without him.
No, I understand.
So it is more like
Yeah.
to honor the law is to breach the procurement contract.
Yeah.
To honor the procurement contract is to violate the law. Because one is pulling up and one is going down.
Yes.
So there must be harmony.
I appreciate that. But isn't it a failure in terms of drawing up a contract that will provide you with what you need? You can't just suck a contract out of your thumb. It needs to stipulate conditions that at the end of the day will leave you with what you are trying to achieve. Now you have a contract, the way you are describing it, you have a contract that is inherently flawed. It cannot provide you with that 24-hour protection because what it is demanding is not in line with the reality.
Indeed so.
Yeah.
It's not in line with the reality, and it's not allowing you to be in compliance with the law.
Yes.
We have reality and we have the law. Reality says the person can get sick.
Yeah.
But you only asked me to give you 4 people.
Okay.
For 4 sites.
Yeah.
Okay? 4 shifts. Each of them, hey, they have their own specific shift, which means you can't move them. They are like, remember, say, procurement model recognize them as object.
Yes.
But the law recognizes them as human being with dignity.
Yes.
Human being who can get sick, human being who can have family urgencies, human being who can have rights to leave. And when they go on leave, both the one on leave and this one coming here must get paid.
Yes. Yes.
So now the procurement agency actually needs to go to the trade drawing board. And this is where I invite the Honorable Minister to really pay attention to this.
Yeah.
Because even the implementation of the hourly rates, the enactment of these new wage orders
Yes.
was not thoroughly thought through. And I'll tell you why. Because it is actually allowing for a vacuum. It's actually leading to absurdity when it's actually applied verbatim.
Yeah. Yeah.
So it is actually, because it would have been better if it says the $13.50 hourly rates, it's inclusive of leave days, public holidays, and Sundays. Because now that is merely exclusive of that.
Yeah.
And the public entities or agencies are applying that. They're only taking that difference and add it to the basic wage of an employee. The employee, on the other hand, is satisfied with their salaries, basic salary.
Yeah.
But they won't be satisfied of their leave days.
Yes. Yes.
And they will still come back to their service provider and say, you don't pay out our leave days.
Yes.
You don't pay me when I'm in the hospital.
Yeah. Yeah.
I don't go, and when I go on leave, you are telling me I must come back, I must come and work because there is nobody there.
Yes.
So it is actually, the law must address the gap.
Yeah. Okay.
The law is more like the owner of the house.
Okay. We've pointed out the deficiency in terms of procurement.
Indeed so.
And we've pointed out the deficiency in terms of the law. But the service providers are not innocent. I mean, there are documented cases of service providers who are blatantly misusing employees, underpaying employees, and just taking whatever profit and even not delivering on what they promise. And yet, we don't see any exposing, any names, we don't see any consequences. The industry protects this. So it seems that there's nobody really in terms of these 3 entities that have clean hands.
You see, Ogaro, you have a point. Look, in every setup, there can always be a black sheep.
Yeah.
There is one guy who is willing to comply, but the governing policies or legal instruments are not allowing him to comply. And there is one guy who's taking advantage of the system, and he's not compliant at all. He's greedy.
Yeah.
But that's not the point.
Yeah.
The law still makes a provision for those to actually be punished in terms of the law. The employees can go to the labor inspector, and then, non-compliance can be issued. Okay?
And what are the consequences?
The consequence of that these guys can be banned from bidding.
But then I just go and register my company under a different name.
Fine. That we cannot actually do anything at this moment until maybe we come up with a law that actually have a database and say, look, this person for the next few days is banned from applying for a company of this nature, for the same service. But again, where do you now draw the line and say Because remember, a company
Yeah.
has a personal, has a legal personality.
Yes.
So are you banning the company or you banning the natural person?
You're banning the company.
Fine. Then a natural person will go open another company because
Yes.
what you ban is the company.
Yes.
So that's where the law becomes a bit complex.
Yes. Yes.
But what we're talking about here is this. We, the custodians of the enforcement of the law,
Yeah.
or actually the upholding of the law,
Yeah.
must do what is right
Yeah.
so that we don't give these guys, the leeway to actually continue violating the law.
Yeah.
So we must make proper provisions.
Uh-huh.
Then they can break the law, we'll get back to them.
Yeah.
But now if we are breaking the law, how do we go back to them and say they are breaking the law? Because we are also not clean. We are failing to actually come up with proper statutory provision that are actually, giving proper, platforms for the compliance of the law.
Yes.
For example, this is so trait in law that a person cannot work in a condition where he's not given leave.
Yes.
A person cannot work in a condition where he's not given, not even lunch interval.
Yes.
Because the procurement agencies say, and they charge them per hours, by the way.
Yes.
So it means if this guy goes on lunch, this hour is not rated. He won't get paid for that hour.
Uh-huh.
But again, if they find, for example, if maybe they find this guy eating in his office,
Yeah.
in the garden room, they would have asked, why are you eating on site?
Yeah.
But where can he eat?
Yeah.
Simply because the procurement method is not proper.
Yes.
That is where we need to start. That's where we need to restructure, and that we must go back to the drawing board. Let's leave everything on the ground. Let's come back to the office, have engagement with maybe the procurement agencies, and really have them understand the operation of security.
Yeah.
I had an engagement with a person one day from one of the procurement agencies. I would say, no, the thing is, if you remove this guy goes on leave, the reason why the service provider is paying for two people is because when this one goes on leave, he's getting paid. Because the law says paid annual leave.
Yes.
And the one they are bringing in to work on his behalf, he can't work for free.
Yes.
And you can't say you are paying me the other guy's money because the other guy's also getting paid.
Yes.
So now the service provider is paying for two people.
Yes.
And then she asks, but why do you have to hire somebody else when that one goes on leave? And I said, it's because of the nature of the work.
Yes.
First, it's security.
Yes.
It means it's 24 hours there.
Yes.
When you remove one, you bring the other. Unlike your office, you can lock your office and go for lunch. And when people call you, say, I'm on lunch, I'll reconvene after 2.
Yeah.
But then they don't have that luxury.
Yes.
They must be there all the time.
Yeah.
But how do we navigate these if the provisions are not allowing them to actually do these?
Yes.
So it's now left in the hands of the service provider and the employee to fight each other.
Yes.
And they're both innocent. It's like the grass suffer when the two elephants are fighting, because the issue is between the procurement models and the labor law.
And the labor law.
There's a huge gap here.
Yes.
This is not allowing this to comply. And when we're talking about the labor law, Ghetto,
Yeah.
we're not only talking about wage orders.
Yeah.
We are talking about the entirety of the labor law. Labor law has got so many sections, so many entitlements,
Yes.
of which these security guards have the same right in terms of the Labor Act as everybody in the office.
Yeah.
There is no exclusion. There is no, you are a security guard, you don't have the same right.
Samuel, our time is limited, so I just want you to leave us with how you would advise us to proceed in order to address the situation. What do you think needs to happen?
Okay, thank you so much. I think what I think needs to happen is the Ministry of Justice and Labor Relations must go back to the drawing board. And there must be an order directed to the procurement agencies that bidding document should make a provision for these entitlements.
Okay.
Any bidding document that only comes asking for the exact number of employees equivalent to the exact number of sites,
Yeah.
that bidding document cannot be in compliance with the order.
I see.
Any bidding document that comes without the provision of leave payout, Sunday payout, night shift payout, cannot be compliant with the wage order.
I see.
Same as the wage order for hourly rate.
Okay.
So they must be included, all of it. One directed to the companies for the wage order, to the service provider,
Yeah.
and one directed to the procurement agencies, in order for the procurement agencies to actually make these guys compliant. Because these guys are unable to comply, and it's not because they don't want, it's because, look, you cannot pay from an empty cup.
Yeah.
You are literally beating an innocent guy.
Okay. No, thank you very much.
Thanks so much, Okito.
And thank you very much for joining us for this discussion on the Evening Review. Tomorrow evening it will be something else, so please join us again. Till then, good night.